Good morning, everybody. Thank you very much for attending today's NECA webinar with Lisa Carey, our Legal Senior Associate here at NECA. My name's Ben Shaw. Most of you will know me as the General Manager of NECA here in Tasmania. Look, NECA is always here to support our members and our industry in emerging trends and emerging issues. IR is one of those things that is very complex in nature, a little bit boring. So I know Lisa's, probably going to try and spice it up a little bit, but it is very important for your businesses. So shortly, Lisa's going to start the discussion around the loopholes in the new bills of IR legislation and how you navigate that as a business owner. Obviously, this session today for Tasmania members is CPD approved. You do have to have signed on, stay on for the hour and make sure you're there to the end. We are here to help. This session is recorded, so we'll be on MKV afterwards. So in your member knowledge base, you can access it or give it to any of your other staff that may need to be aware of some of these changes. We'll also have a question and answer at the end, so please, if you can leave your questions to the end, write them down on a pad as you go, or I think there's a comment section, so you can write them in the comment section. Of course, you can also always contact myself, and we can put you in contact with Lisa after the session as well if you have any further questions. So I'll hand it over to Lisa Carey from our legal team.
Thanks, Ben. So that's me. As Ben said, might be a bit dry today. I apologise in advance. There are a lot of changes going on in the workplace relations space at the moment. Every time I look around, there's a new model term or a clause that's come into effect, and so we're going to try and go through as much of that as we can, but there is a lot of information, there's a lot of changes, so don't feel too overwhelmed. We're always here if you want to come to us at any point in the future or after this, and we can answer your specific questions. Now, some of you I may have spoken with already, but yeah, as Ben said, I'm the senior associate in the team and the practice manager for the workplace relations. I only practice in this area of law. I do love it, although it is keeping me on my toes at the moment. And I've been with NECA since October. I just would like to say that this presentation has been funded by the Australian Chamber of Commerce and Industry, or ACCI, who we do a lot of work with and who advocate for businesses such as yours and all of those in the electrical contracting industry. We are grateful to be able to work with ACCI on this, to be able to provide this training to our members. Okay, so as I mentioned, there is a lot to cover today, and what I'm going to have a look at is a brief overview of the Closing Loopholes Bill, followed by a summary of the changes resulting from that bill. I'll let you know what NECA is doing to advocate for its members' needs and concerns, and then hopefully we'll have some time for questions at the end. So first, an overview of the Closing Loopholes Bill. As many of you know, the Fair Work Legislation Amendment Closing Loopholes Bill 2023 was introduced to Parliament in September last year. It has, there was an additional 278 pages proposed for the Fair Work Act, which is already a pretty large piece of legislation as it is. It now sits over, I think, 1,200 pages, and a couple of years ago it was 700 pages. So it just shows how much has changed over the last couple of years. Initially, it was a single bill, but after the parliamentary inquiry, which NECA represented its members at last year, they decided to separate it into two tranches. The first tranche contained the less controversial provisions and was passed into law on the 14th of December last year. And the Closing Loopholes Bill number 2, which was the second tranche, was passed by Parliament in February this year, with a sneaky little addition in the form of a right to disconnect. Okay, so let's start with Closing Loopholes Bill number 1. This is a little timeline of some of the changes we've already seen and some yet still to come. And the majority of these, as you can see, came into effect on 15th of December last year. And then there are a few that are happening sort of over this year and the beginning of next year. Some of these changes include workplace delegates' rights, family and domestic violence protections, small business redundancy exemption, union entry to assist with workplace health and safety representatives, the labour hire orders, protected action ballots, workers' compensation claims for first responders experiencing PTSD, and the silica agency, or the expansion of the asbestos agency to include silica. There is also, on 1st of July, the criminalisation of industrial manslaughter, and on the 1st of November, same job, same pay. And then, yeah, sorry, at least 1 January 2025, we're not quite sure yet the exact date, criminalisation of wage theft as well. Okay, workplace delegates' rights. The rights of workplace delegates has expanded, whereby a workplace delegate appointed or elected by a union to represent its members now has the right to represent union members in industrial disputes, reasonable communication with members about industrial matters, and has reasonable access to workplace facilities. Delegates employed by non-small businesses, which are employees that have more than 15 staff members, are further entitled to reasonable paid time during regular working hours for training. The changes also introduce general protections with potential penalties prohibiting employers from unreasonably refusing to engage with delegates or knowingly providing false information to them or obstructing the exercise of their rights. As of 1 July 2024, all awards and enterprise agreements voted on after the 1 July now must contain a term providing for the exercise of these rights for workplace delegates. NECA did consult with the Fair Work Commission regarding the wording of this model term, which is now in effect. It is quite a long term, but we have started putting that into all of our enterprise agreements that are being voted on from now on. So to ensure you comply with this change, you should be aware of who is a workplace delegate at any given time in your organisation and comply with the model term. And like I said, it will need to be included in all enterprise agreements going forward if you're an organisation that has one. If you want a copy of the term, if you want to understand what that looks like, it will be, I think it's in the awards now, but I can send you a copy of that if you like. Right, family and domestic violence protections. We did not have an issue with this change. Basically, there are now stronger protections against discrimination for employees facing family and domestic violence. Similar to sex, gender, pregnancy, race, etc., family domestic violence is now a protected attribute under the Fair Work Act, and employers are unable to discriminate or take adverse action, such as dismissal based on an employee's current or past experience with family and domestic violence. This protection extends to potential future employees also. So when you're in the recruitment process, you cannot discriminate on someone because they've experienced domestic violence. Further, awards and enterprise agreements must not contain terms that discriminate against employees due to their experience with family and domestic violence. Not that I think any of your agreements would, but it's just something to keep in mind. So what you can do here is you can create or review any policies regarding discrimination and include this new attribute. You should then provide a version of the updated policy to staff and train them if necessary, making sure that you identify the new requirements and make sure that everybody's on board with what that means. Redundancy exemption. So from the 15th of December last year, changes were introduced regarding redundancy pay for employees in the context of downsizing. Typically, small business employers are exempt from paying redundancy to redundant employees where the business has fewer than 15 employees. However, now if a non-small business becomes a small business due to insolvency or bankruptcy or liquidation, the employer was previously exempt from paying redundancy to employees, but now they must pay that as they would have if they were if they were still a large company. And so yeah, basically it just means that non-small businesses that become small businesses because of the liquidation or bankruptcy must pay redundancy to affected employees where they are made redundant within 6 months of the bankruptcy or liquidation. So the impact on the business is that they must factor in redundancy costs for all employees if the business becomes a small business due to insolvency within that 6-month period. And I guess you'll see this often when you'll have sort of iterations or tranches of redundancy, and the business gets smaller and smaller, and you end up with this sort of skeleton crew at the end. A lot of sort of maybe finance, HR people are the ones that tend to go, maybe a couple of the operations people. Under the previous laws, they actually weren't entitled for redundancy once the organisation went with 15 employees, but now they are, and I think that's not an unreasonable thing. So we didn't actually have an issue with this when we were advocating for our members. The right of entry to assist workplace health and safety representatives. So from the 15th of December, union officials can now enter premises to assist a health and safety representative without requiring a union right of entry permit. This means that, unfortunately, there are no checks and balances on who can enter a worksite without a permit if they're using this as the reason. Consequently, businesses will also therefore have limited recourse to influence the union behaviour while on site for this purpose, with restrictions, obviously. So the amendments include requirements for officials entering premises in these circumstances to comply with reasonable directions from employers relating to workplace health and safety, not intentionally hinder or obstruct any person or otherwise act in an improper manner, not misrepresent rights that the official may exercise as a health and safety representative's assistant, and not use or disclose information or documents obtained as a health and safety representative's assistant for an unauthorised purpose. Further, in these circumstances, the amendments will impose requirements on other persons, such as employers and occupiers, to not refuse or unduly delay entry onto premises by a union official, and to not intentionally hinder or obstruct an official who is assisting a health and safety representative. So what to do here is update your policies and procedures around right of entry and train staff on the changes, stay up to date with the right of entry requirements and enforce them where legal and necessary. Okay, so labour hire orders, which I know a lot of our members are interested in. The changes to the labour hire orders came into effect on the 15th of December last year, and there are now new rules for labour hire workers with regard to same job, same pay. The new or the changes allow employees, unions and host employers to apply to the Commission for an order that labour hire employees must be paid at least what they would receive under a host's enterprise agreement. The Commission can only make an order if satisfied the host's enterprise agreement would apply to the labour hire worker if they were directly employed and where a valid exemption does not apply. Now, some of those valid exemptions are where it is not fair and reasonable in all of the circumstances to do so. The Commission will have regard to submissions in this respect. For example, whether the host employer's instrument is of limited application, so it might only be going to the end of a project, for example, that project finishes in 3 months' time. The history of industrial arrangements between the employer and the regulated host, and whether they are related bodies, corporate or a common enterprise. Another exemption is where the arrangement is for a service rather than a supply of labour to a host employer. The Commission in this instance will consider the extent to which the employer directs, supervises or controls the employees when they are performing the work, including by managing rosters, where they assign tasks or review the quality of the work, if they, to the extent to which the employees uses the employer's systems, plant or structures to perform the work, and the extent to which the work is of a specialist or expert nature. Another exemption is staff that are engaged by the direct employer as trainees under state or territory training arrangements, such as apprentices and trainees. And another important one is short-term employment arrangements are also exempt. So this is usually periods of less than 3 months, and this is so that it doesn't impact labour hire for surge work and where short-term replacement workers are needed. So sorry. So yeah, host employees under certain circumstances are obligated to notify and apply for variations with the Commission. Exceptions to these orders include situations deemed unfair, services other than labour supply, such as specialist contracts, and cases involving small business employers. Now, disputes regarding labour hire orders can be escalated to the Commission, and penalties apply for non-compliance, including prohibitions on arrangements hindering or avoiding the Commission's orders. So the impacts of this actually won't be felt until 1st of November 2024 when the orders come into place. Although the laws they are in place from the 15th of December, and orders can be made or applied for up until the 1st of November. They actually don't come into effect until 1st of November. So I'll look at that in a little bit more detail on the same job, same pay 1st of November slide. Protected action ballot. Okay, so a protected action ballot is a secret vote by eligible employees on whether they want to take industrial action for a proposed enterprise agreement. Where the Fair Work Commission has made a protected action ballot order in relation to a proposed enterprise agreement, they are required to make an order directing all bargaining representatives for the proposed agreement to attend a mediation or conciliation, which they may want to host at short notice. I have actually had some where they give you 2 hours notice, and the employer was actually on a plane, as was I, and they only gave them a very short extension of time. So they want to get this done very, very quickly. So the impacts of this is for industrial action to be protected. The employee bargaining rep who applied for the protected action ballot order, and the employee must attend that mediation or conciliation conference. What to do is attempt to resolve any issues in the bargaining process if possible. Obviously, that's not always possible. And if it's not possible, then make yourself available for the mediation or a conference. Now, in my experience, if you do get to the point where you are in that mediation or conference, the Fair Work Commission will generally approve the protected action ballot, unless you can prove that the other party is not genuinely bargaining. Now, there are sort of rules and regulations around what that actually means. So if you do find yourself in a position where you're being asked to attend a mediation, or you're just not able to resolve issues in bargaining, you're worried that it might go to this, and you feel that they're not genuinely bargaining, then give us a call and we can actually give you some advice on whether they are or they aren't bargaining. Okay. So there are, there's a lot of changes, and I've only put the ones in here generally that will relate to you, but there are a couple of others. So streamlining the Comcare workers' compensation claims process for certain first responders who sustain PTSD, which I don't think will impact many of your well, any of your employees, I dare say, but the functions of the Asbestos Safety and Eradication Agency was also expanded to include silica. So this may impact some of you who work in that construction space. Again, if you need more information on that, just give us a call and we can provide you with that. Another one that was is probably of interest to a lot of people is the industrial manslaughter legislation, or the changes to the legislation here. So penalties including incarceration in relation to industrial manslaughter are currently generally dealt with at a state or territory level in either the relevant workplace health and safety legislation or their criminal code. However, from 1st of July this year, the Commonwealth Work Health and Safety Act 2011 will be amended, or was amended, to introduce a new criminal offence for industrial manslaughter and significantly increasing penalties for other offences such as Category 1 offences. An industrial manslaughter offence for the Commonwealth Work Health and Safety jurisdiction provides for penalties of $18 million for a body corporate and 20 years imprisonment for an individual. If you are in a state or territory that already has this criminalised, and probably not a lot will change, but for those of you who don't, and I'm actually not 100% sure about Tasmania, but it will impact officers, so it's something to be mindful of. Under the Work Health and Safety Act, an officer is a person who makes or participates in making decisions that affect the whole or a substantial part of the business or undertaking. So that may cover a lot of people that don't actually realise that they're officers. They can be held personally liable for industrial manslaughter and other categories of breach under this legislation. So it's really important to know, A, if you are an officer, and B, what your obligations and your liability is if something goes wrong. So for Category 1 offences, the penalties have increased from to 15 million for a body corporate, 3 million for a person conducting a business or undertaking of an officer, and up to 1.5 million and or 15 years imprisonment for an individual who commits an offence. That is significant. What I would be recommending that organisations do is to conduct an audit of your WHS policies, SHWIMs, procedures to ensure that they are sufficient. Now, NECA does have a safety arm of the business or an area, and they will be more than happy to help you do this, and they're very good. They obviously have a great understanding of what the policies should look like, what your SHWIM should look like from an industry perspective. So give us a call and ask for the safety team if you need some help on that. We would also be recommending you provide training to staff and officers on WHS policies and procedures, and also ensure that officers within the organisation review the WHS policies and procedures in their area to make sure that they know what they are, what they're comfortable with, what's been put in place, because like I said, there is a possibility that they may be held personally accountable, and ignorance is generally not a good defence. Okay, so I'm moving on from the changes for labour hire. The same job, same pay comes into play on 1st of November 2024 this year, and basically that means if there is a labour hire order in place, it is the obligation of the host employer to provide the labour hire employers with a copy of the new agreement or of the agreement, and you would need to then comply with any order from Fair Work with regard to the payment. So you would need to pay at the host's rate of pays. The impact of this will be that there may be an increase in cost of labour hire employees and increased obligations when signing a new enterprise agreement. And what to do, again, we recommend reviewing your contracts and use of labour hire and like start considering reviewing your need for labour hire going forward. You might like to consider using fixed term contracts if your enterprise agreement allows for it, especially for periods greater than 3 months. I'd be keeping track of any labour hire orders that are made by the Commission between now and 1st of November, so you know what's going to come into play on that date. And start thinking about amending contracts with labour hire companies to ensure that they are paying their staff at your enterprise agreement rates if there is an order in place. If you're a company that does a lot of tendering or quoting, you may also like to consider the increased project costs when tendering or costing work that does involve labour hire workers. Okay, that's Bill 1 done. Now let's move on to Closing Loopholes Bill number 2. So again, there's a little timeline here, and the changes to the Closing Loophole Bill include changes to enterprise bargaining, changes to amalgamation rules, changes to defence for sham contracting, increased penalties for breaches of certain workplace laws that after 27th of February, and on the 1st of July, there are changes to the right of entry for suspected underpayments. The majority of the laws kick in on the 26th of August, because that's 6 months after it was ratified, and this includes a new definition of casual employees, changes to the casual conversion process, definition of employer and employee. There's also change to the employee versus contractor test. There will be the right to disconnect, as many of you will have heard about. Increased penalties for breaches of workplace law. I'll go into what those workplace law breaches are. Changes to how unfair contract terms can be disputed, and the new union right of entry to investigate underpayments. There's also other changes, like changes relating to gig workers and road transport workers, but I don't think they're really relevant here, so I won't go into that. But if you do have any need for advice on that, give us a call. Okay, changes to enterprise bargaining. From 27th of February 2027, multiple employees who are franchisees for the same franchisor or related body corporates of the same franchisor can access a single enterprise stream in the enterprise bargaining framework if they want to, where they couldn't previously. There will be new rules around the transition from a single interest in employer agreement or supported bargaining agreement to a single enterprise agreement. And there are changes to intractable bargaining determination provisions. Now, an intractable bargaining determination is where the Commission decides on the terms and conditions of employment where the bargaining representatives are unable to agree. There have been well, basically, yeah, this allows for the fact that the terms in these determinations can't be less favourable to employees than the same or similar terms in the existing enterprise agreement. And there have been a couple of cases on this recently. There was a case that came out, I think it was last week, maybe it was the end of the week before now, that looks at what constitutes agreed terms, and this has kind of given everybody, I guess, a good understanding of going into a one of the determination hearings as to what is an agreed term. We have done a case note on this, and that is available on MKB. But if you want us to send it to you, if you're thinking that you're heading down the path of an intractable bargaining determination, then give us a call. We can help you out. Okay, amalgamation rules. So the new amalgamation rules repeal the changes made to the Fair Work Registered Organisations Act in December 2022 that covered demergers of amalgamated registered organisations. The new provision means that there is again the requirement to demerger applications from amalgamated registered organisations within 2 to 5 years after an amalgamation occurred. And it should also be noted that the Commission is the registered organisations regulator. Now, this will only really impact you if you are a registered organisation looking to demerger. And again, if you are, we can help you if you need advice at that time. So sham contracting, we do get a lot of requests for advice on this because it is well, previously it was very complicated or it was tricky to identify if it was a sham contract or not. So we would provide a lot of advice to organisations on this. Basically, the changes from 27th of February mean that there is a change to the defence to sham contracting. And as you might know, sham contracting is where you misrepresent employment as an independent contractor arrangement. And generally this is done for tax benefits or for flexibility to terminate without recourse under the Fair Work Act. So the old test was that an employer didn't know and wasn't reckless with regards to a sham contracting arrangement, whereas now the test is whether the employer reasonably believed it was an independent contracting agreement. Employees who have incorrectly classified an employee as an independent contractor may now be penalised for sham contracting unless they can use this new defence. And the defence, unfortunately, is harder to establish because businesses must prove that their belief in the contractor principal relationship was reasonable at the time of the representation. So the new defence provides that an employer has not contravened the sham contracting provisions if, excuse me, at the time of the representation, the employer reasonably believed the contract of employment was a contract for services. And in determining whether the employer's belief was reasonable, regard will be given to the size and the nature of the employer's enterprise and any other relevant matters. So what you can do here to try and avoid sham contracting is to review your current contractor agreements and assess future agreements having regard to the differences between an employer and contractor arrangement. Again, if you need help with what the Commission will look at when determining whether something is an employee or an employer relationship, we can help you there. So changes to increase penalties. There are, from February this year, the maximum civil penalties that can be imposed by a court for certain contraventions of the Fair Work Act will increase fivefold from 60 penalty units to 300 penalty units for individuals and organisations. There will also be an increase in the maximum civil penalty a court can order for failing to comply with a compliance notice. If litigation is successful, a court may impose orders against a person found to have done the wrong thing. So what does that mean in real terms? Looking at the maths, currently a penalty unit is worth $330 as of 1 July this year. They go up every year. Last year it was $313. So the changes will mean the court can order a payment for a breach of up to $19,800 per contravention for an individual and $99,000 per contravention for a company, which is quite significant. In addition, there'll be a new threshold introduced for what constitutes a serious contravention under Section 557A of the Fair Work Act. And when looking at this, the criteria has changed. So there's now 2 criteria, and only one of those has to be satisfied. The first criteria is that the person knowingly contravened the provision. And for body corporates, this occurs when the body corporate expressly, tacitly, or impliedly authorised the contravention. As of the 27th of September, there is a second criteria which has changed from the person's conduct constituting the contravention as part of a systemic pattern of conduct relating to one or more other persons to the person was reckless as to whether the contravention would occur. So, yeah, these changes are significant. They will alter the likelihood of liability for higher maximum penalties for serious contraventions. Now, a serious contravention is when the person or business knew they were contravening an obligation under workplace laws, and the contravention was part of a systemic pattern of conduct affecting one or more people. So the higher penalties for serious contraventions apply to breaches of a lot of stuff that you guys will be doing on a day-to-day basis. So the national employment standards, your modern awards, your enterprise agreements, workplace determination, a national minimum wage order, an equal remuneration wage order, method and frequency of paying wages, unlawful deductions, including cashback schemes, guarantees of annual earnings, record keeping requirements, and payslip requirements. So there's a lot there that if you breach any of that, then you're potentially liable for those sort of higher penalties. Okay, so right of entry for underpayments. This is from July 1st, a new one. So a registered organisation such as a union is able to get an exemption certificate from the Commission to waive the 24 hours notice requirement if they reasonably suspect a member of their organisation has been or is being underpaid wages or other monetary entitlements. This only applies where the Fair Work Commission is satisfied that the advance notice would interfere with the investigation. So if they have the belief that you are currently or could start, I don't know, getting rid of evidence or shredding documents. Sounds very like a Tom Cruise movie, but yeah, they'll obviously approve it on that basis. The impact of this is that union officials can now enter your premises without notice, obviously with that permit, but without notice, so you won't know before they get there. Further, you will not be given the opportunity to make any submissions to the Commission prior to them approving the exemption certificate, so they only have the word of the union to go by. So what to do? We would be recommending that you audit your payroll, make sure you're paying people what they are entitled to, respond to employee or union queries regarding pay in a timely fashion, and if you need us to help you, we do provide a complimentary audit on your payroll. You can sort of provide us with sort of 5 different pays, and we can see if you're paying people correctly, give you a bit of peace of mind in that regard. Okay, so what to do around the increased penalties as well? When I'm advising members or clients of what to do, it always reminds me of this clip from Liar Liar, which I love. Fair warning, there is a swear word in it. So, actually, there's no. This version doesn't have the play option. Anyway, basically it says stop breaking the law and then a swear word. But I don't think anyone's intentionally breaking the law, but it is the simplest way to comply. So what we recommend you do here is to know the laws, understand the laws, and put policies and procedures in place to ensure compliance, and then make sure your staff are trained on how to comply with the law and what is expected of them if well, in regards to this, and what consequences they might or consequences there are if they fail to comply. Now, these consequences could be internal consequences such as disciplinary action, or external such as liability under various legislation. Of course, again, if you need any guidance on this, please just give us a call and we can help you out with your specific scenario. And just before anyone asks, no, Jim Carrey is not related to me. All right, definition of casual. So under the new laws, there will be a new definition of casual employees included in the Fair Work Act. The new definition will say that an employee is a casual only if there isn't a firm advance commitment to continuing or indefinite work, factoring in the real substance, practical reality, and true nature of the employment relationship. And the employee is entitled to be paid a casual loading or a specific pay rate for casuals, which is that 25% loading. The impacts of this is you cannot rely on what your contract says alone anymore, and you will need to regularly assess casual arrangements. I'd probably be doing that every 6 to 12 months, probably 6 months in light of the new casual conversion process, which I'll go through in a minute. And yeah, so basically what we just do is we recommend is assess them regularly and actually set up time frames and reminders to do that. So moving on to the casual conversion process, which has changed. And I actually think the casual conversion, or this new casual conversion pathway, is actually good for business. Up until 26th of August 2024, to be eligible for casual conversion, a casual employee needs to have been employed for at least 12 months, work an ongoing regular pattern of hours for at least the last 6 months, and be able to continue working this pattern of hours as a part-time or full-time employee without significant adjustment. The employer is obligated within 21 days of the 1-year anniversary of the employee starting to either offer them conversion to permanent employment or advise that they are not being offered, and on what grounds. Under the new pathway, it's employee choice pathway, and the onus is on the employee to request the change to their employment status after 6 months or 12 months for small businesses by notifying their employer that they believe that they no longer meet the definition of a casual employee, and if the employer accepts the notification, the employee's employment status will change to permanent employment. Now, although the employee has the right to request this, it should be noted that under the new pathway, the employer may still refuse the employee's request on fair and reasonable grounds, including the employer believes the employee is correctly classified as a casual employee and shouldn't move to permanent employment. There are fair and reasonable operational grounds for not accepting the notification. So this might be that there won't be any need for the person in 3 months' time because there's a big restructure going on or something like that. Or that a change of employment status would not comply with the recruitment or selection process required by a federal or state or territory law. If the employer does not accept the notification, they must advise the employee that they don't accept it and on what grounds. So that would be one of those grounds I've just mentioned. And any disputes about casual conversion will now be dealt with by the Commission. So we'll start seeing, well, we might start seeing a few cases come through after 26th of August. Unfortunately, I don't have a lot of case studies for you at the moment because nothing's been tested yet. That will all start to come through, and we'll get a bit more feel for how all of these changes are working in practice. Okay, so the definition of employer and employee. The Fair Work Act will include new statutory definitions of employee and employer, where the real substance, practical reality, and true nature of the relationship is considered when determining whether a worker is an independent contractor or employee. Now, I don't know about you, but this saddens me greatly. Some of you might remember prior to the High Court decision in Workpac versus Rosado in 2021 and personnel contracting and JAMSEC in 2022, the mess that was created by having to assess the nature of a relationship by using a multi-factor test when determining whether a relationship is employment or contractor. It was difficult. Even the Fair Work commissioners, they didn't seem to be able to agree on a consistent approach, and it was very challenging for employers and employment lawyers even to provide advice on how an employee should be classified. The High Court did make a ruling that I was pretty chuffed about, and most employment lawyers I knew or were also, and we thought it was quite sensible. It was that you go by what the contract says. So if the contract says it's an independent contractor relationship, then that's what it was. Much easier and quicker. Unfortunately now, this new law means that the confusion has been legislated by reinstating the requirement that the substance and true nature of the relationship is to be looked at in conjunction with the agreement. thus reverting back to the need for this multi-factor test. It should be noted that independent contractors who earn over a specific high income threshold may opt out of the new employee definition, whether their principal contractor has asked them to or not. I'll go through that in a little bit more detail shortly. But the impacts are basically that you can't rely on what your contract says anymore, and it's going to probably be more difficult to categorise with confidence whether a worker is a contractor or a contractor or an employee, creating uncertainty for businesses and other organisations which have traditionally relied on non-employee workers. So what to do? We would be reviewing current contracts and assessing each new employment relationship, updating recruitment and contracting policies, train relevant staff such as managers, HR people, and those involved with hiring and drafting contracts. We would consider which individuals are independent contractors or employees by recognising the differences between written contracts and how they play out in practice. And this assessment might need to be an ongoing assessment as well as roles change. And we would also be recommending that you identify those highly paid independent contractors once the high income threshold is prescribed, which it hasn't yet been. And consider whether it would be appropriate for those contractors to utilise the opt-out mechanism. Noting that the opt-out mechanism may have limited benefit for principals, considering the independent contract can actually retract that opt-out notice at any time. So there's nothing, nothing to say that that is a set in stone opt-out, unfortunately. Okay, right to disconnect. So the right to disconnect is obviously very topical, and you've probably heard a lot about it through the media. Under the new laws, which come into play on the 26th of August 2024, all employees will have the right to refuse, monitor, read, or respond to contact from an employer outside their working hours unless that refusal is unreasonable. This right extends to contact from customers and clients as well. Now, I just want to note that this does not mean you're not able to send your employees an email after hours. God knows I'd be in trouble if that were the case, but it just means that generally the employee may not have to read or respond to the email until they are back working, unless it is not reasonable for the person not to respond. So attempts to resolve a dispute about an employee's right to disconnect must first be made at the workplace level. If unresolved, an application may be made by the employer or the employee to the Fair Work Commission, who may make an order to either prevent the employee from continuing to unreasonably refuse to monitor and respond to contact outside of hours, or to stop the employer requiring a response to contact attempts. Any breach of such a Fair Work order can result in civil penalties being imposed. So yeah, there does seem to be a bit of wiggle room on being able to request your employees to monitor and respond to after hours contact where that request is reasonable. And when determining whether an employee's refusal is unreasonable, the following factors must be considered. So the reason for contact, why are you calling? Why couldn't it wait? Were there financial implications or operational implications for contacting the person? Did a decision need to be made? Was time of the essence? You may like to weigh up the consequences of not contacting a person when deciding whether it's appropriate to call somebody after hours. Another one is the form of contact and the level of disruption it causes the employee. So an email or a text may be less disruptive than a phone call or a Teams message. When you send that message as well will also should be considered. Did you send or call them 5 minutes after they finish work, or did you call them during their dinner or 11 o'clock at night? Both are very different levels of disruption and need to be considered accordingly. Should also consider the extent of the employee's compensation to perform work outside of their ordinary hours. Are they paid overtime or penalty rates for any contact after hours? Do they get time in lieu? Has the compensation been expressly built into their salary or wage? Obviously, if there is some form of compensation or express provision in a contract or an award, then it may be unreasonable for that employee to refuse to monitor and respond to contact after hours. Another thing you should look at is the nature of the employee's role and responsibilities. Is the person a senior manager? Do they deal with international clients or transactions? Are they paid handsomely to do their role and to take those outside of hours calls? Or is it a lower level employee who may not be paid a lot and there may not necessarily be the expectation that they should respond after hours? Another thing is the employee's personal circumstances, including a family or caring responsibilities. Do they have a family? Do they need to pick up kids from school, daycare or sport after hours? And are they unable to do that if they're being contacted and expected to log on or to do some work or answer questions? And then the final one is whether or not the relevant contact is required by law or was for the reason of emergency or genuine welfare. So this is going to impact the business, it'll impact your communications and operations within the business potentially. And if you are found in breach of a commission's order, can result in civil penalties, as I mentioned earlier. Further, now that this is an entitlement under the Fair Work Act to discriminate or take adverse action on an employee who reasonably refuses to monitor, read and respond to communication outside hours can enliven a general protections claim, which you would ideally like to avoid. So what to do? I would be recommending updating your policies, position descriptions, job adverts, contracts, etc., to include the right to disconnect as being satisfied as part of their compensation or their remuneration if there is if it's above the award, for example. I would consider on-call, overtime or standby payments in compensation for connecting with staff after hours if that's applicable or reasonable. I would ensure you know the ordinary working hours of all employees. Now, I know this can be difficult, particularly with people who work from home. That's a bit of a grey area that I'm expecting the Fair Work Commission to have to determine some disputes on. So yeah, that might be, we'll have more information on that going forward, and training staff and managers on laws as well, and what they can and can't do in this regard, and what they should consider when they're thinking about contacting somebody after hours. Now, NECA has been in consultation with Fair Work Commission on what the model term will look like. The model term will take effect on the 26th of August as well, and it will be in all awards and enterprise agreements. We did advocate for the term to be restricted to that of the statutory provision and not include any additional obligations or requirements for the employer. And we are pleased to advise that the draft term that the Fair Work Commission released a couple of weeks ago did actually do that. And it has just limited it to that, the statutory right. They are going to wait to provide a guidance. They have under the laws, they've got to provide a guidance for this as well, but I think they're waiting basically to see how the law works in practice and what disputes come out of it. So I'll keep you posted on when that comes out. We can give you some more information on that at the time. We're also in the process of preparing a little training video for you, which will go into a lot more detail. Alternatively, if you would like us to provide training to your management team or your supervisors, etc., we're happy to arrange that for you also. Okay, so I'm conscious of time, so I might have to sort of shoot through these next few, but unfair contract terms. From 26th of August, independent contractors earning below the specific contractor high income threshold, which is yet to be determined, can dispute allegedly unfair contract terms in the Fair Work Commission. The Independent Contractors Act 2006 will continue to apply in respect of independent contractors paid above the new contractor high income threshold to challenge their contract terms, though that jurisdiction has rarely been used. The impacts is that the Fair Work Commission is more cost-effective jurisdiction and applicant-friendly, so it might result in increased disputes being filed. But what you can do is just review your contract terms in templates to ensure the terms are fair. Look at your restraint clauses. They're generally where some of these the unfair terms will come in. We can help you with that if you like as well. We can give your contracts a little bit of a review if need be. Okay, so what is NECA doing for its members? Basically, there's a lot going on in the background. We continuously are advocating for our members in a number of different ways. We're building relationships with the unions and the governments to advocate for the best outcome for our members. And a lot of, like I said, a lot of work goes on in the background that you might not be aware of. As you can imagine, we're currently consulting with Fair Work Commission departments and various committees with regard to the upcoming changes. We assess those, we look at them from the perspective of our members and make submissions regarding this. We also attend consultation meetings and research interviews and provide feedback on model terms, etc. It actually seems like a bit of a full-time job at the moment, to be honest. There's a whole lot going on, as this whole hour has shown you, and so there's a lot of advocacy that we are doing in the background. We're also members of the Small Business Committee, where I meet with other employer organisations, the Fair Work Commissioners, Fair Work Ombudsman, departmental heads, etc. And we discuss changes and needs of small businesses, and they consult with us on various changes, messaging, communications, and interactions with decision makers, which is it's a good forum actually, and I get a lot of useful information on what is going to happen or what the Fair Work Commission's intentions are with regard to a lot of these things, and specifically with regard to small businesses. We're also a member of ACCI, so the Australian Chamber of Commerce and Industry. We meet regularly to discuss NECA members' needs and upcoming changes to legislation, and we are consulted on their submissions and often support their submissions when they align with the needs of our members. And we also educate NECA members, so things like this. We provide training, MKB. We're sort of doing, we've done a bit of an overhaul of that, so we're adding more information on MKB that is educational, but by all means, if there's an area that you want more information on, or if you think a training would be useful or an information sheet or something, please let us know, because if you think that, then other members might as well, and we can try and help you out there. Okay, Ben, I'm not sure if we have a lot of time for Q&A. What are your thoughts?
That's okay. We might just throw it out there just quickly. I think if our admins can allow some questions, if anyone has any questions, feel free to throw them up. But whilst we do that, I can just run through a couple of things. Thanks, Lisa. Obviously, there's a lot in industrial relations, and it isn't a sexy topic, but it is extremely important for our members to be across some of this legislation. And as you've mentioned, anyone can certainly contact you or us, or through via myself or member services, or directly with you if they need anything. So, is there any questions from the floor or from the screens? If not, we might move on to, I think you've got the slides, Lisa. We might move on to the next couple of slides, and then if there's a question, I'll come back to it if something comes through, and then we'll just close it out.
Okay. Yeah.
So as we all know, we have legal advice and support. So as you've heard today from Lisa, and you put a face to the name, please feel free to reach out. One of the things I found out of that discussion is that confidential wage review. I think that's something that's really important. Of course, we have our work health and safety reviews as well, just to make sure we're keeping all of our employees safe and in good shape. I'm not going to go through all the things there, but you've got your debt recovery and contracts, so reviewing contracts and those types of support mechanisms as well through NECA. I'll go to the next one, workplace relations, so that's all covered under Lisa's area as well, and that expert advice. So again, if there's anything there that sparks your interest and you would like to have a chat to Nika about how we can support you better in that space, please reach out. I've talked about the annual confidential wage review, so Lisa mentioned that and I've mentioned that, so that's something that we can offer if you would like to reach out. And as usual, just contact us for any advice and support. We all know that I am here based in Tasmania, so you can reach out to me at any stage. We offer a whole range of different things. I think the webinar forum is a good forum. Again, IR is probably not overly exciting, but Lisa made it as exciting as possible and to the point, and hopefully you got something out of it. If there's anything else from the members that you'd like to see in this forum, so anything else in industrial relations or HR or legal, work health and safety, technical, on a forum like this, we can obviously get CPD points for it for those who need them, but also just as a general update, please reach out to me and we'll see if we can create some content for you as well for our Tassie members. But otherwise, there is no questions. Thank you very much, Lisa, for that in-depth overview. And again, if anyone needs any support around any of our support mechanisms through Nika, please reach out.
All right. Thanks, everyone, for your time.
Thank you.